Defense Fund and Child Focus. We're thrilled to have you all join us today to show an interest in the kinship provisions of fostering connections. We have an hour of jam-packed with informative presentations about progress that's being made on implementation. First, we want to tell you about some of the important features on the webinar system and also to give you a general overview of the Fostering Connections Resource Center. We'll then move into a more substantive presentation by the Children's Defense Fund about the kinship provisions of the legislation, focusing primarily on the options states have to implement a guardianship assistance program and the identification and notice requirement. We will then hear from two states, Michigan and Rhode Island, about their experience implementing the guardianship assistance program. Throughout the presentation, you will also hear about a new kinship toolkit that was released earlier in the week through the Resource Center's Kinship newsletter. The next slide is an overview of some of the special features of the webinar system. On the right side of your screen, you should see a control panel. To open and close the control panel, simply click on the Grab tab or the double white arrows to the left of the panel. The question feature also allows you to post questions during the webinar. To ask a question to presenters, type it in the box and hit send. We'll try to answer as many questions in between presentations as time allows and hope to have time for additional questions at the end of the webinar. Any questions that we do not have time to answer will be answered after the webinar. We'd also like to point out that your phone lines are all set to mute, so questions can only be posed by using the question feature on the control panel. Any questions that you do not ask on today's webinar can always be posted through the website at a later time. For those of you who are not familiar with the Resource Center on Fostering Connections, it was formed in October 2009 to provide timely and accurate information about implementation of all of the provisions of the legislation. It's supported through a partnership of 9 foundations dedicated to effective implementation of the law. 4 major activities are undertaken by the Resource Center. First, the provision of nonpartisan data and resources on each section of the bill. Second, individualized technical assistance to states, localities, and tribes. Third, monitoring of implementation activities. And fourth, opportunities to interact with national experts and peers on implementation challenges and opportunities. The Resource Center has 6 networks that correspond to the major provisions of the Fostering Connection legislation. Today's webinar is brought to you by the lead partner for Kinship, the Children's Defense Fund, along with Child Focus as the Kinship Network Manager. I'd now like to turn the presentation over to Mary Lee Allen and Beth Davis Pratt from the Children's Defense Fund. Mary Lee and Beth worked tirelessly on behalf of Kinship families and were instrumental in helping gain passage of Fostering Connections. They'll provide an overview of the kinship provisions of the legislation and guardianship assistance provision before turning it over to our 2 states who are implementing the program. We will also take 1 or 2 questions after the state presentations. Mary Lee?
Thank you, Jennifer. This fall, as all of you know, will mark the 2nd anniversary of the Fostering Connections to Success and Increasing Adoptions Act, which includes some of the most significant reforms for abused and neglected children in foster care in more than a decade. The Act focuses on promoting better outcomes for children and addressing racial disparities. One of the major purposes or goals of the new Act was promoting family connections. Several of the provisions are focused specifically on promoting connections and permanent placements for children through kin. Our challenge at the Resource Center and yours in states and communities across the country is to ensure that children truly benefit from these important provisions. This afternoon, we will focus on the Fostering Connection provisions in the bill. Throughout consideration of the Fostering Connections Act, the voices of alumni of foster care and relative caregivers kept pulling us back and pulling members of Congress back to these important family connection concerns. There are about 8 major provisions in the Act that promote family connections through kin, and I'm going to run through them very briefly before we take a more detailed look at a couple of them. First, there's a requirement which took effect upon passage of the new Act that states must identify and provide notice to relatives within 30 days of a child being removed from the custody of his or her parents. This provision was included to increase the likelihood that a relative might be able to be a resource for the child, either as a placement outside of foster care, as a foster parent, or as a friendly visitor or contact while the child is in foster care. And I'll come back to this in a little more detail later in the webinar. Secondly, there were federal funds broadly available for the first time for a new guardianship assistance program. States can apply for funding to assist relatives caring for children who become guardians committed to caring permanently for a child. Beth will spend more time walking through the specifics of the Guardianship Assistance Program, or GAP, as it's come to be known, and some of the progress and implementation around GAP. Third, the Fostering Connections Act also established a new Family Connections grant program. At the end of fiscal year 2010, last September, 24 grants were funded for 3 years, with awards ranging up to $1 million. These competitive grants are to help states or other grantees expand or implement a range of different activities: Kinship Navigator programs, intensive family finding activities, family group decision-making projects, and family-based residential substance abuse treatment, or 8 of these grants actually provide funding for a range of these different activities, multiple activities in the same site. HHS has announced that there will be no new grants for 2011, but there'll be an opportunity for these 24 sites to be able to get up and running and continue to move forward. I also wanted to mention that more detail on these specific grants is available on the website of the National Resource Center for Permanency and Family Connections at the Hunter College School of Social Work. We also hope to be able to do a later webinar featuring some of the Family Connection grantees as we move forward. Another important provision in the legislation was the requirement for the first time in federal law that reasonable efforts be made to place siblings together, or at least connected in care, when it's contrary to the child's safety or well-being to place them in the same home. The law specifically talks about frequent visitation or other ongoing interaction when placements together aren't possible. I think it's also so important to remember that it was really the alumni of foster care that helped members of Congress realize the importance of this sibling provision. And they were eloquent when they talked about what the loss of being able to be placed together with their siblings meant to them. Many states had already been making efforts to keep siblings together, but I think it's important to point out with regard to this provision that the Act specifically requires that efforts to place siblings together be documented in a child's case plan. There was also another important provision in the Act that recognized that licensing requirements can sometimes be a barrier to placing children with relatives. And it reinforces that case-by-case waivers for non-safety licensing standards may be granted for relative homes, and required states to report to HHS actually by last December on the extent to which they were using these waivers. Training was another area that was addressed in the Fostering Connections Act, and there were a number of improvements in Title IV funding for training, but one of them specifically made clear that these funds can be used for training of relative guardians as well as for foster and adoptive parents. And there are 2 last provisions that assist specifically older youth with kin, and let me mention both of those just briefly. First, states that decide this coming October to extend federal support to children beyond age 18 may extend federal support for kinship guardianship assistance payments to youth to ages 19, 20, and 21. It's important to keep in mind, though, that this provision only applies to those youth who moved into guardianship at age 16 or older. So the ability to include them in the option for extending care to older youth is to a limited number of children within guardianship. The other important provision for older youth was the opportunity for states to cover children who exited to guardianship at age 16 or older in terms of their independent living services and education and training vouchers. There was a problem in the past in that it was really a disincentive in some cases, and relatives were holding back on permanently caring for children because of these, because of that disincentive that existed in the past. So now I'm going to, after that quick run through, turn the screen over to my colleague Beth Davis-Pratt, who will provide a more in-depth look at the opportunities that the Guardianship Assistance Program provides.
Thanks, Mary Lee. As Mary Lee mentioned, Fostering Connections gave states the option to use Title 40 for guardianship assistance on behalf of certain children leaving foster care to live with relatives. If your state is still considering whether or not to take the option, we would of course encourage you to do so and wanted to let you know about the new Fostering Connections Kinship Toolkit we created. A number of pieces in the toolkit will help you walk through some of the questions you'll need to answer to start figuring out the fiscal implications for your state and also to make the case for taking the option. Other resources will help states to implement the option. We have provided links to the toolkit later in the presentation and will mention relevant pieces throughout the webinar. Along with the ongoing financial assistance and providing for the non-recurring costs of establishing guardianship, GAP ensures that children continue to have access to Medicaid and continued eligibility for adoption assistance as long as they are eligible at the time of guardianship, should their guardian later decide to adopt. And states can begin claiming reimbursement for guardianships established on the first day of the quarter in which an approvable state plan amendment is submitted, and you can do that through your regional office. States may also choose to claim reimbursement for guardianships entered into prior to Fostering Connections or prior to taking the option, provided the children and guardians meet all the federal eligibility requirements and the state has set up a process for documenting how those requirements are met. And this may be particularly helpful to states who had subsidized guardianship programs prior to Fostering Connections. And let's turn now to those specific eligibility requirements for the federal program. First, for children. In order to be eligible for GAP, children must be eligible for 40 foster care maintenance payments for at least 6 consecutive months while living with a prospective relative guardian. So they must be in a licensed home. They must also have a strong attachment to the prospective guardian, and reunification and adoption must not be appropriate options for the child. Sometimes this is referred to as rule-out in shorthand, but the Act says not appropriate. And we see it as determining in each individual case whether or not reunification and adoption are appropriate for individual children. And of course, the reasons will vary as to why they may or may not be appropriate in individual cases. Finally, if the youth is 14 or older, they must be consulted about the guardianship. This doesn't necessarily mean that they must formally give their consent in court, but they must be consulted. While typically guardianships will end on the youth's 18th birthday, as noted here, some youth will be eligible beyond that age. For instance, youth with what the federal law still refers to as a mental or physical handicap will be eligible to age 21, just as youth with similar conditions who are adopted are eligible for adoption assistance to the age 21. This will go into effect on October 1st of this year. It's also important to note that regardless of their own eligibility, siblings of children who are eligible for the GAP program are also eligible if they're placed in the same guardianship arrangement. This will help to keep siblings together and is also something states should think about when thinking about fiscal implications for taking the GAP option. If one sibling comes in and is Title 40 eligible, meets all the eligibility requirements, and exits to guardianship, then later another sibling comes in but doesn't meet the 40 eligibility criteria, that sibling could still be placed in the guardian's home with their sibling and be eligible for GAP funding. For states that were operating Title 40 subsidized guardianship waivers on September 30th of 2008, the children receiving assistance under those waivers on that date will also be covered under the GAP, regardless of other criteria. Now turning to the requirements for guardians. In order to be eligible for the GAP program, a guardian must be a relative. However, the law does not define relative, and so far, HHS has approved plan amendments with broad definitions that include what some people refer to as fictive kin, godparents or family friends. The other requirements for the guardians include that they have a commitment to care permanently for the child, that they have cared for the child for at least 6 consecutive months, that they are licensed as a foster parent, and they must enter into a guardianship assistance agreement with the state, and we'll talk more about that in just a minute, and that they must assume legal guardianship. Turning to the case plan requirements now. The case plan requirements you see here on the screen are all directed to ensure that there is documentation to show that return home and adoption are not appropriate and that both have been fully explored. For example, there must be documentation of efforts to discuss adoption with the prospective guardian and why adoption was not chosen, and efforts to discuss guardianship with the parents or why those efforts were not made. You can see that all are also meant to ensure that these decisions are looked at with the circumstances of each individual case in mind and made carefully on a case-by-case basis. We often get questions about whether the requirements regarding kinship or education or siblings trump one another. The federal law doesn't set a hierarchy for these decisions because it recognizes that individual circumstances are different in each case and relies on good casework to make the right decision for each family. Now looking in more detail at the Guardianship Assistance Agreement, many of you may have experience with adoption assistance agreements, and a binding agreement is required here too. It is meant to ensure a clear understanding of what the agency and guardian are agreeing to. The federal law sets out a number of items that must be addressed in the assistance agreement, and you can see all of those items on your screen. We've also developed a sample guardianship assistance agreement as part of the Fostering Connections Kinship Toolkit, and it incorporates all of the required elements. That may be helpful to some of you as you think about developing your own. Also, as part of the toolkit, we developed a guide to using the Guardianship Assistance Agreement that tries to answer some of the questions that may come up as caseworkers, caregivers, or attorneys are going over the agreements. The Guardianship Assistance Agreement is distinct and different from the court's order granting guardianship. The Guardianship Assistance Agreement specifies the obligation the agency has to provide the guardian and child with assistance and services, and spells out the obligation of the guardian to advise the agency of any change in the guardian's circumstances or needs of the child. The court's order granting guardianship to the relative, on the other hand, sets forth the guardian's rights and responsibilities for the care of the child, and in some cases may also address visitation of the parent. And to give a quick update on state implementation before turning it over to our state guests, 37 states and D.C. operated subsidized guardianship programs prior to Fostering Connections. However, not all were designed similarly to the GAP program. Some states may want to continue operating both programs. About a year and a half after passage of the law, 1/3 of all the states have submitted state plan amendments to take the GAP option. 4 have been approved and have begun moving children to permanency under the new program. And we'll be hearing from 2 of those states, Michigan and Rhode Island, in just a couple of minutes. We know that 13 states are still waiting to be approved, and we at the Kinship Network and the Resource Center would love to know what those of you in those states are hearing from HHS and what questions are coming up as you develop your programs. I should also mention that grandfamilies.org is tracking state kinship legislation, and you can find a link to their website on the Resource Center as well. Before I turn it back over to Jennifer to introduce our guests from Michigan and Rhode Island, I'd like to direct your attention to a few of the resources we've created in our Fostering Connections Kinship Toolkit related to GAP to help states with the decision to take the GAP option and then to implement it once the decision has been made. These resources can all be found on the Fostering Connections Resource Center website by clicking on Resources and then clicking Kinship Toolkit. The first 3 listed here are those I mentioned earlier that we hope will be most helpful to those of you still considering whether to take the option. They look at the fiscal implications, some myths and facts related to using the GAP program, and provide several reasons that will help to make the case for taking the GAP option from both a fiscal and permanency for children perspective. We have also included sample state legislation to implement GAP for those of you who may need to enact or make changes to legislation to comply with the federal requirements. Then there is the State Guardianship Assistance Agreement and the guide to using that I mentioned earlier. Finally, we have a checklist for the program, and I've noted the chapter on the GAP program in the Kinship Q&A called New Help for children being raised by grandparents and other relatives, questions and answers about the Fostering Connections to Success and Increasing Adoptions Act that you can also find on the Resource Center's website. And now I will turn it back over to Jennifer to introduce our guests.
Great. Thank you very much, Mary Lee and Beth. And now I'm very pleased to present our first state presenter, Anita Peters. She's from one of the trailblazing states that has received approval to implement a guardianship assistance program from the state of Michigan. Anita is the Adoption, Guardianship, and Permanency Manager of the Child Welfare Bureau at the Michigan Department of Human Services. Anita.
Thanks, Jennifer. In Michigan, we had actually passed legislation to develop a guardianship subsidy program. And as our act was being signed into law by our governor, we became aware that there was a major effort underway to combine the various federal pieces of legislation to create Fostering Connections. And luckily, we're able to pull it all together and pass an amended piece of legislation that was signed into law in April of 2009 that integrated our state legislation with the Fostering Connections requirement. Some of the differences that we had to deal with right off the bat, the differences from our state legislation and what the federal requirements were around licensure, that was a major shock to our coalition and partners that relatives were going to have to become licensed in order to take advantage of this. We had to do a lot of education, a lot of work around, convincing why licensure was a good thing and would be of a benefit to the guardian, not only because it would make them eligible for guardianship, but for lots of other reasons, certainly around child safety and stability, and certainly giving comfort to the court as they were making decisions about moving to permanency and taking away their supervision. The post-licensure six-month residency requirement also was a difference that we had to take into consideration from what our state legislation was going to originally require, and required some additional work, especially in many cases where we had children that had been living with the same relative for 2 or 3 years, unable to leave foster care because of needing the financial support or the casework services if they weren't licensed, and so that required some changes as well. Certainly, our decision was to integrate these two programs as closely as possible so that we could adopt all the federal requirements and take advantage of the federal funding to stretch our funding even further. Originally, our legislature allocated $4.65 million for the Michigan program. That is money to be used as our match for the federal funds, as well as provide some state funding for those children that aren't eligible for the guardianship subsidy underneath the federal requirement. The previous presenters, Mary Lee and Beth, both talked about the decision about ruling out reunification and adoption, and certainly that is a key part of our planning process in order to move children to guardianship subsidy in Michigan. We borrowed very heavily forms and language from the 37 states that were already mentioned, really looked very closely at what Illinois was doing, and really borrowed and heavily used their forms. And so I really recommend the caseworker and caregiver permanency planning checklist. Those were really helpful documents to us in both actually implementing the program and using that today, but also in being able to train and explain to all the various stakeholders what we're talking about when we are ruling out reunification and adoption as appropriate permanency options before we move to guardianship. And I do a lot of training around the state with different groups about this program because it is still very new and people have a lot of questions about it. And one of the most common, I guess, little rules that I'll say is if we don't do this guardianship, this child will remain in foster care. So we know that reunification is no longer an option. We know that that adoption is no longer an option. So guardianship really is our third and our last permanency that's available on the continuum that's going to allow the family to take the child and to leave our foster care system. Otherwise, they're going to remain in care with our continued support. Certainly the federal requirement helps us to do that language as well. We look for that in all of our case plans. We want very clear and specific language that those discussions were held with both the caregiver and the child and the birth parents if the child is a temporary court ward, if the parental rights are still intact. We want to see specific language that those discussions were held and why was reunification and adoption, why were they ruled out, and why is guardianship most appropriate. And so we look for that language. We ask the court to look for it as well before these are finalized. For children that are temporary court wards, all of those applications for the subsidy agreement are reviewed in our guardianship program office. We are a state-run system, so state-administered system, so our program office at the state level, we review all those. And then the office, we have a somewhat unique situation in Michigan where we have a Michigan Children's Institute that provides all the approvals for adoptions for children that are permanent state wards in the state. And the way we set our program up was to have that same office review guardianship applications for those same children. So that office has to give consent for those children to enter into guardianships, just like that office gives consent for those children to enter into adoption. And like I said, in any temporary state court wards are reviewed by the program office. Certainly, probably one of the greatest challenges we faced in getting this program off the ground in Michigan has been just getting the information out to the state. We have 83 counties that all have very unique needs, county systems, court systems, stakeholder groups. And while we have one program, a federal program and a state program that we're trying to implement, each county has some different needs in terms of how they're going to implement it. And certainly the courts are very interested in it and using it as an option, but want a lot of information about how to best use it. And so a lot of the time since this program was implemented this last July 1st, so coming up here in a few weeks will be our one-year anniversary of having the active program in Michigan, has been spent on training. I've spoken at numerous judges associations meetings, both on the statewide level and on the county level and regional. We've done a statewide webinar in partnership with our state court administrative office, spoken to numerous relative caregiver groups, foster care groups, a lot of different associations who would have an interest in this program with lots of questions about how it best be used. Certainly our relative caregiver coalition groups in Michigan are very powerful entities, as they are in many states, and have a very strong voice about the work that they do. And there has been some concern about this funding being only available for children in the foster care system. And so it's been a continuous discussion about not only clarifying the proper use of this program for those children in foster care, but also as to how we can use other funds and other programs to support relative caregivers that would not be eligible for this program. And that's really been an ongoing and will be a continuous discussion. The third part, I think, of increasing the awareness has been around the data. We maintain obviously lots of reporting around the guardianships that we are doing, and a regular part of that, using that data, is giving it out to the counties and giving it out to the courts, so they can see on a county level how many guardianships they've applied for, where it is in status, and also so they can see on a statewide level how the program is being implemented. And I think that's been really helpful. As one of the many states in the country that are under a lawsuit settlement agreement, we are under a 5-year agreement currently with Children's Rights We have a lot of reporting that we are doing, a lot of work we're doing to meet the requirements of the settlement agreement, and does require a lot of looking at permanency options for our kids. We're tracking a couple of cohort groups, most specifically looking at their permanency goals. And so we have a lot of very focused work happening in our state anyway around permanency. I think in many ways the timing just couldn't have been better for our ability to actually implement this at a time when we were probably looking at permanency closer than we've ever looked at it before, and really trying to ascertain for our children in foster care if the appropriate permanency goal is assigned to that child, and then how do we get them to permanency. On this last slide, I provided some links to our policy and to our forms and to our pieces of legislation. So if that's helpful to folks, I'm also more than willing to answer any questions or to provide any other feedback that I can. Certainly other states that had this in place before we did were very helpful to us, and I certainly want to make that available as well. We currently have about 2,500 children in our state foster care system with a goal of guardianship. As of a week ago, we had 160 agreements that had been applied for. 70 of those are in place. 70 some are in place and are being funded because of the licensure requirement and the 6-month post-licensure residency requirement. It did not go as quickly as we had originally anticipated because we had relatives who were under the impression that they would be able to move this fairly quickly once the legislation and the program was put into place. And because of the licensure requirement, it did take some time. But I think we're seeing more and more movement in that direction, and more applications coming in. And so we're really pleased with that. Jennifer had asked me about providing just a quick, case example, and I'm happy to do that. Probably the most remarkable, I think, use of this program that we have seen have been around our temporary court wards. For many of our children who have parents that have mental, physical handicaps that prevent them from caring for their children 24 hours a day, 7 days a week, but who otherwise are connected to their children, in the past, the only way that child was going to achieve any kind of legal permanency was for us to terminate the parental rights, which I think, broke a lot of families, certainly broke a lot of relatives' hearts to have to do that in order to adopt their children. One of the, I think, most touching stories that I've been aware of since our program came into being was a group of 4 children that were living with their grandparents. Dad has been out of the picture pretty much since the children were born, but mother is very much connected. But mom lives in an assisted living facility a few blocks away. The children visit their mother every day, grandmother. And it's a wonderful setup, but they were forced to remain in foster care because there were no options for them that they could really accept. Guardianship provided them with a means to reach permanency, maintain the family relationships, the family connections, and leave our system with supports in place that they needed in order to care for these 4 children. And I think this is exactly what this program is for, and I'm happy every day I get to see one of those stories happen.
Thank you so much, Anita, for that great overview of Michigan's program. And we will, again, take questions after our next presenter from the states. Our next presenter is Kevin Savage. Kevin is the Administrator of the Licensing and Regulation Division at the Rhode Island Department of Children, Youth, and Families. Rhode Island was the first state in the nation to be approved to implement a guardianship assistance program. And we're very pleased to have you here with us today, Kevin.
Thank you. Rhode Island actually began looking at this issue of funding guardianships back in 1994 and got approval to do that. In practice, it never really took off philosophically, and most of the funding came through the TANF program at a very low rate. DCOF only funded the guardianships that were non-relative, and there were very, very few of them. In 2008, in fact, so after 14 years of implementation, there were only 14 active guardianship subsidies. Now, that doesn't actually mean that kids didn't age out or didn't close to the department through guardianships, but through our database, we never actually tracked them. If they were funded by TANF, we had no way of knowing that once the case closed out. So it wasn't a program that was watched in any kind of sophisticated way, and not one that the administration of the department actually bought into in a philosophical way. And the only kids that really were qualifying for it were older kids in the system. It didn't really look at the whole family, but limited it very much to kids 14 years and older.
Kevin, are you able to flip through the...
Oh, I'm sorry.
That's okay.
Actually, no.
Okay. All right. We'll work that out and
okay.
Get back to you.
Yep.
Yeah, I'll go ahead. Reset your mouse, Kevin.
Okay.
So try it again.
There it is.
There we go.
Okay. So as efforts to promote permanency grew, the state began to promote guardianship under the direction of our new director, Patricia Martinez, and help the staff, particularly the administration, to see the long-term benefits for children and families and recognize the economic benefits for the state. And I know most states, by that point, were going through some economic difficulties, which only became worse. But the real issue wasn't the economics. It was what was best for families. And I think, as my colleague in Michigan said, terminating rights of parents when it wasn't the best thing for the families, we began to realize was just inappropriate and just causing more problems for families than we needed to cause. The kids whose rights were being terminated, eventually the parents were coming back into the families anyway, and so we needed to see what was best for the families, and guardianship just became a more reasonable, better permanency effort for the kids and families. And one case that really stood out to me and really helped me buy into this issue that guardianship was the way that the department needed to support some families was a case where parents of an adoption subsidy child, they actually adopted 3 siblings, but the oldest of the 3 had been diagnosed with reactive attachment disorder and ended up having a child of her own who she wasn't able to parent and was aging out of the system. And the grandparents of the baby now wanted to care for the baby but didn't want their daughter's rights terminated to her own child. The regional manager who's overseeing the case was having difficulty philosophically buying into establishing a guardianship for an infant, still tied to the old practice that we only did guardianships for older kids. There was a conflict between the regional director and this grandparent who really believed in her daughter that at some point as she got into her 20s that someday she'd be able to parent her own child, and was very committed to working with their daughter and being a grandparent to her grandchild rather than seeing this termination and a breakdown in the family that didn't need to occur. She and her husband were both MSWs, very committed to understanding the full impact that this would have emotionally on the granddaughter, and appealed to my office in permanency to help them not move to terminating her daughter's rights. There was a petition filed to remove the child from the home because they believed that this grandparent wasn't cooperating with the department's plan. And to make a long story short, we were able to work with the regional manager on removing the order to have the child removed. And within really just a few weeks, a guardianship was proposed to the court. The mother of the child agreed to the guardianship with her own parents, and the case closed within 30 days to the department. And they haven't been involved with the department since, and that was about 3 years ago. And the issue that really brought it home to me was this was a family that was capable of taking care of themselves, capable of permanently committing to a grandchild and a child. They'd seen this child grow. They adopted her when she was 7 with enormous mental health needs, yet had stuck by her through all of the difficulties in her own childhood and were permanently committed to seeing their daughter through working out her mental health issues into adulthood. They didn't need the department involved in working with her, and certainly were able to work with their daughter's mental health needs and commit long-term to their granddaughter. And guardianship was the answer in that case, even though it was an infant. And I think a lot of the staff in that region who were involved were able to see this as an example of why guardianship would work in a case where in the past we only would have considered adoption. The tragedy in that case, when it would have happened in other cases, is it would have meant removing an infant from a family absolutely committed to the infant's permanency. So that was a success where in the past we would have actually seen it as removing a child who never should have been removed from the home. Not long after that case was involved, maybe a year or so, that the federal government committed itself to funding through Title IV adoption subsidy agreements, and the department began, because we had already developed a subsidy program, developing its state plan amendment to submit to the federal government, and worked with the federal government in getting a 4A state plan amendment approved. Oops, I apologize. So we adapted our adoption. In doing so, and getting our 4E subsidy approved, we adapted our adoption assistance agreement to meet the program requirements for federally subsidized adoption subsidy agreement. The background checks for guardians were the same as those for adoptive parents. We really tried to make the two programs parallel, because we recognize both adoption and guardianship as kind of parallel permanency standards. We wanted permanency to drive the issue and not federal funding, so we tried very hard to make sure that we didn't differentiate between federally funded guardianship subsidies and those being funded completely by the state. And so in working with families, it's really a seamless process. If the funding is going to be from the state, or if the funding is going to be from the federal government, there's actually no difference from the family's point of view. They don't see a difference. We just fund them, and then if they can be reimbursed through the federal government, we do. Otherwise, it's seamless to the family. The benefits that the family receives are the same. In terms of implementing it, we did regional trainings throughout the state in order to get the staff to buy into permanency and to understand why guardianship permanency is important to understand, and implement it on a case-by-case basis when it makes sense. In doing so, guardianships have increased from in 2008 to only 4 active guardianship subsidies to 48 so far in 2010. There have been 55 new subsidies activated since the state plan amendment was approved. The thing that we're most proud of is that adoptions haven't decreased, so that guardianship hasn't replaced adoption as an option, but has increased guardianship permanency outcomes in addition to adoptions, and I think that was one of our main goals, and also one of our chief concerns, that people would look at guardianship as an easier avenue to adoptions, but that really hasn't happened, and that's something that we're very pleased with. One of the things that I did want to mention as a caveat is that Rhode Island's efforts to achieve permanency goals is still a work in progress. We haven't met the standards set by the CFSR, and so we recognize that while the guardianship program is a success and we want to continue to build on that as we continue to increase our adoption numbers, we recognize that it's yet one more piece in the puzzle, and that we have continued work to do, as many states do, but recognize that we're not there yet and want to continue to work toward improving our permanency goals. So thank you.
Thank you so much, Kevin, for that great overview. I want to thank both Anita and Kevin for those terrific presentations. It's exactly how we expected that states would be using guardianship assistance, and the stories that you both told really bring home alive how it can positively impact children and families. We had one question that came up in our question box about whether or not any of the states are researching how the outcomes for their guardianship assistance programs. And so I would ask both Kevin and Anita if research and or evaluation is a component of your programs.
Yes, we actually have someone who works on data, so I can't speak specifically to it, but there's a person on data who actually is responsible for outcome measures. So in we have permanency teams that are involved in helping cases get further along in the permanency process, and there are outcome measures associated with that, and someone in charge of data who actually reports back to the department on permanency outcome measures, and guardianship is one of the outcome measures that are measured, as is adoption and other permanency outcomes.
Great, thank you. Anita, did you have anything to add to that?
I would echo that. We have written requirements to track any disruptions or dissolutions in guardianship the same way we do in adoption into our state SACWIT system. So we will have a very real way of seeing long-term what happens, because, as I look at, especially with the temporary court order cases, I mean, I want to know what's going to be the story 5 years down the road, 10 years down the road, especially when we're looking at some of these younger children. And so, yes, we're tracking it now, and we'll continue to do that.
Terrific, thank you. And I think we have time for one more question. A question has been posed from another state, and I'd ask you both maybe to consider a 30-second to a 1-minute answer about what somebody in a state that has not taken up the option can do to promote taking the option in their state if it has not yet done so.
Let's see. I think it depends on philosophically where your state is. So one thing is getting buy-in from key players and stakeholders in your state that guardianship is an important tool and an important permanency option in that it actually is meaningful and one that families want. So if you're there, then the next step is working with HHS on actually getting the details worked out in terms of getting your state plan amendment taken care of. It was actually a process that was very cooperative in our state. It was detail-oriented, but a very cooperative one, and I think one that was successful. And it didn't really take all that long looking back. It seemed like it at the time, but once the cooperation and the buy-in was here in the state, I think the process went along relatively smoothly.
Yes, and I would echo what Kevin said. And additionally, for one of the things I think that was really helpful in Michigan, as many states do, we use relative placements a lot for children in foster care. So the data that we were able to gather really helped tell the story of potentially how many children this could impact in terms of getting families to permanency. And certainly for situations where termination was not appropriate, and for an option for older youth who were not going to be willing to consent. In Michigan, children 14 and older are allowed to consent to their adoption. For those children who just refused it, for many of those older kids, guardianship doesn't seem to pose as great a barrier to them as adoption does. So it was very helpful, I think, to look at the data.
That's good.
Great. Well, I'm sure that will be useful advice to our states who are still considering how to take up this option. Thank you very much, and I want to now turn the presentation back to Mary Lee to explain the identification and notice requirement in the legislation. First, I'd like to mention that in addition to other webinars that we'll mention before we close today, the Kinship Network will host a webinar in the fall that will provide more in-depth analysis of the fiscal issues associated with guardianship assistance options. So stay tuned and look out for the announcement on that. Mary Lee?
Thank you, Jennifer, and thank you, Anita and Kevin, for all the great work being done in Michigan and Rhode Island to make the Guardianship Assistance Program truly benefit children and families. It's always difficult in these sorts of presentations. I would love to just keep on talking more about the Guardianship Assistance Program, but while a lot of attention has been focused to the Guardianship Assistance Program, certainly when we look at permanency opportunities for children, the requirements in the Family Connections Act for identification and notice to relatives are really very much related. Getting relatives knowing that children are about to enter foster care and seeing different ways that they can be involved as we move forward. Identification and notice are two provisions that took effect when the law was passed, and they refer only to those children who enter care after that time. There's been some question about, do we have to now provide notice to relatives for all children in care? The law reads in a way that it's children who entered care about the time the law was passed. So it's within 30 days of their entry into care. So children entering care then and subsequently to that time. The Act doesn't define relative. When you look at the specifics of the provisions that are on the slide, it doesn't define relative and it doesn't define due diligence. So there are opportunities there for the states to decide how they're going to define them. I think it's also important to keep in mind, and this is an area where we've gotten some questions as well, that the notice requirement is not a requirement that relatives be given priority for placement. States may have such laws in their individual states, but it's only a requirement that relatives be given notice and advised as to how they might care for or stay connected with the child. So I think it's important. Certainly notice helps provide the opportunity for relatives to come forward, but it is just that, a notice requirement. It's also, I think, important in looking at this notice requirement that many states say, well, we've always had a notice requirement, or we've had a notice requirement for a long time. But as we go through the specifics of the provision, you may hear some differences between what the Act actually requires and what was done in the past. For example, we know there's some states that have required notice, but they've required it within 60 days or 6 months. Others require notice to relatives about hearings that involve a child, but that's different than an initial notice when a child is first removed from their parent's home. So I think very important distinctions there as we move forward. Okay. Clearly, notice means more when states are also required, as they are by the Act, to take steps to identify relatives. We've listed on this slide examples of strategies being used to identify grandparents and other relatives. And I think it's important to reinforce here that there is a family violence and domestic violence exception, both to the identification and notice requirements that are in the law. I think it's also important, as we're looking at identification and relatives, to think about what other activities are already going on in your state. Family group decision-making meetings, work through intensive family finding, other sorts of activities that you could use to make clear that you were making diligent efforts to identify relatives. So it's important to think about what you're already doing as you move forward. I also wanted to highlight the first one, which may seem obvious, ask parents, but I mention it because the Act specifically refers to notice to any adult relatives identified or suggested by the parents. And sometimes takes a while to help parents understand why you're asking for these suggestions and to move through that particular process. Oops. One of the important provisions that's happened as we okay, didn't we miss one? Just a second, I think I pressed a little too vigorously here. Parent locator service. This new technology is giving us a challenge for a second.
Mary Lee, can I help you get to a slide?
Yes, the one that says identification of relatives, it's number 33.
Okay. There you go.
Just as easy as pie, and you aren't even in the room, so that's pretty sad there. Let me try now. I think we're ready to move to the next one. One of the things that's particularly important when we talk about identification of relatives is some new news. On June 7th, just a week or so ago, the HHS issued a notice of proposed rulemaking with regard to the Federal Parent Locator Service and the State Parent Locator Services. And in the Fostering Connections Act, the Federal Parent Locator Service was specifically mentioned as a way to help identify relatives for children in care. At the time, however, child welfare agencies only had the opportunity to use the Federal Parent Locator Service to identify a parent of the child. And what this NPRM provides is to allow its use to assist agencies to locate other relatives of children removed from their parents' custody as well. So we really encourage you all to take a look at it. Don't be discouraged by the length. I think it's 60 pages or so. But if you look, you'll see specific provisions which are noted at the end of this PowerPoint, that specific provisions that deal with the child welfare provisions. And comments are due at the end of beginning of August, by August 6th of this year. So we encourage you all to take a look at that because it could be very helpful in identifying relatives as it's required. Let me spend just a minute on the core components of the notice that are required by the Fostering Connections Act. The Act is very specific about what notice covers, and we've listed them here on the slide. I think what's important is that this is one of the obligations, because notice is a state plan requirement that states must comply with. It's also been interesting as we've looked at different notice letters across the country to see how states have accommodated these particular requirements. Obviously, you don't want to get so much in the notice letter that you're going to scare relatives off when they first open it. And some states, Wisconsin, for example, has developed a question and answer format that gets to these questions and makes it very accessible for caregivers. Kansas has attached a special brochure that describes supports available in the community. So there are really ways to take a look at this as we move forward. There have been a number of lessons learned that we've learned as we've looked at some of the state notice letters across the country. And again, I'm not going to walk through each of those. We hope those guidance will be helpful to you. But the Fostering Connections Act, although it doesn't require written notice to relatives, I think most states, a number of states at least, have recognized the value of written notice in really documenting that notice has been provided and ensuring that relatives get the required information. Some states have designed response forms that go into detail about which of the activities is it that relatives are interested in participating in. And you can really check off boxes of what you'd like to follow up on a little further. Some states also provide a form for the relative to fill out that specifies the name and contact information for other relatives who might be available to help provide a connection for the child while the child is in care. Some states are also, and this is a particularly important provision, I think, have taken some special steps to ensure that relatives actually get notice. This is a state plan requirement, so it's to the state's benefit to be able to show that they have, in fact, done the due diligence as they move forward with this requirement. Written notice helps, but in Arizona, they have a response form that relatives can send in so it can actually be placed in the child's file. They also have put a field in their SACWA system related to notice, and actually there are several states that have done that. And this summer, they have plans in Arizona to send a policy analyst out to the field and to track implementation, to pull some random cases and to see how well identification and notice are going. We'd also suggest that you might want to work closely with grandparent caregiver organizations in your particular states. Maybe you could hold some focus groups or to get their sense of, is this notice getting out? What's been the response? Do relatives need extra help in understanding what their response is to be as they move forward? I think it's particularly important, though, as you're looking at these kin issues in your states, to remember that the identification and notice provisions are particularly important in making real the opportunity to maintain those family connections. Finally, as we look at resources with regard to identification and notice, I just wanted to flag a couple. Many of these are part of the Family Connections Kinship Toolkit, the Fostering Connections Kinship Toolkit that Beth mentioned earlier, and you can find them there, the sample letter for notice to relatives, a very helpful key considerations for implementing notice to relatives piece that was prepared by Generations United and the ABA Center for Children and the Law, as well as others, and another checklist, and again, a chapter in the Kinship Q&A that can be particularly helpful. And as promised, we've included at the bottom of this slide the link to the recent Notice of Proposed Rulemaking on the Federal Parent Locator Service that we hope you'll all take a look at as we move ahead. Jennifer, back to you.
Terrific. Thank you so much, Mary Lee and Beth and all of our presenters. We are coming to the conclusion of our webinar. There have been a number of questions that have been posed about both the GAP and the notice provisions. We're sorry that we could not get to them all. Some of them require a little further research. And so we are committed to, within the next few weeks, answering all of your questions. And in addition to answering them privately, we will get a whole list of the questions, because you may have some questions you hadn't even thought about, and the answers to them up on the website, along with an audio recording of the presentation, as well as the PowerPoint. We understand some of you were not able to see the PowerPoint. We apologize for that, but you will be able to access that later. In addition, I'm going to be putting up my all of our contact information. You can contact any one of us through email to get a copy of the PowerPoint presentation. So to conclude the webinar, we would hope that you will regularly visit the Fostering Connections Resource Center website. You can ask additional questions through the information section. It also houses all of the resources that you heard about today, as well as many of the other resources that address other provisions of the Act. Now, I am not able to go through. There we go. Thank you. We also invite everyone to join our new discussion forum with subgroups around each of the major provisions, including kinship. You can find more information on joining this forum by following the link provided on the slide from the PowerPoint, and that's underneath the column that says discussion forum. And I'll hold that up for just a few more minutes in case you want to copy that down, but it will also be again on the PowerPoint that will be posted to the website very soon. And Carrie, I guess if you could flip to the next slide.
Sure.
Finally, you'll see contact information for the Children's Defense Fund and Child Focus, and for additional questions about the kinship provisions. And some of you may have missed the contact information for our state presenters, and I'm sure there will be lots of questions for them, and that will be up on the PowerPoint. Or again, you can send any one of us an email, and we will send that contact information to you later. So thank you once again to all of our presenters, Kevin Savage, Anita Peters, Beth Davis-Pratt, and Mary Lee Allen. This concludes our webinar on fostering connections through kin, and thank you so much for joining us.